Oh.
Hello, Steve Kidler here.
Good morning. Agenda item 1 is the call to order. It's 9:30 a.m. on July 27th, 2023. I call this meeting of the Citizens Clean Elections Commission to order. With that, we will take attendance. Commissioners, please identify yourselves for the record.
Galen Payton.
Damian Meyer.
Yeah, Steve Kidler here.
Okay, we have a quorum. Thank you very much, Commissioners. Item 2, discussion and possible action on minutes for the June 22nd, 2023 meeting. Is there any discussion on the minutes? If not, do I have a motion to approve them?
I'll make a motion to approve the minutes.
Okay, motion to approve the minutes. Is there a second?
My second.
Thank you. Motion made by Commissioner Payton, seconded by Commissioner Titla. I'll call the roll. Commissioner Payton,
Aye.
Commissioner Titla,
Aye.
Commissioner Meyer.
I'll abstain since I wasn't at the meeting. I can't verify whether they're accurate.
Okay, thank you. Chair votes aye. The minutes are approved 3-0 with 1 abstention. Item 3, discussion and possible action on the executive director's report. Tom?
Yes, thank you, Chairman and Commissioners. I wanted to hit a few highlights from this report. First, shockingly, it's next week is August 1st, which begins the qualifying period for participating candidates in the Clean Funding Program. That means that those candidates can start to collect their $5 qualifying contributions from registered voters in their district, or in the case of corporation commissioners candidates, registered voters in the state. This is always an exciting time of year. So, you know, we have had, although obviously the usage of the program, that part of this program has diminished over the years. We've always had strong and consistent usage among the Corporation Commission candidates. And I think this year will probably not be an exception. And I also think that, you know, Corporation Commission is every year as the state develops, the Corporation Commission becomes a more important part of what in fact the government of Arizona does. There is a election date on August 1 as well, with Prescott and Tucson conducting mayoral and council ballot by mail elections. And then the other thing note, and there is a report attached to this, you know, Mike's report on the legislative activity is attached to this. Just a quick note there, the legislature will continue the session on Monday. And, you know, nobody really knows what'll happen. They may come in and maybe sine die. They may come in and then leave again. From news coverage and certainly in Mike's outreach, you know, we know that, you know, that the biggest reasons that are kind of historical, in order for Maricopa County to impose a countywide sales tax, the legislature has to actually approve that first. That the tax was last extended, I want to say 10 years ago. It would expire in 2025. So that's been something people want to do. So that's been the main remaining issue, although there's a lot of chatter about the budget going forward. And that's something that we keep an eye on for a variety of reasons, not the least of which is, you know, what does the budget picture look like in 2020, fiscal 2025 and 2026, et cetera. I wanted to talk a little bit about the voter education and outreach in particular. A couple of things that I wanted to really highlight. Yesterday, Avery was a panelist on a McCain Institute panel entitled Arizona's Youth Electorate, Exploring the Political Behavior of Young Swing Voters. some of us on staff, and I know Chairman Kimball got a chance to watch that panel. I thought it was a great opportunity for Avery. I thought that he did a very, very good job of articulating specific both aspects of the history of youth voting and specific actions that organizations, whether it's Clean Elections or other folks who are involved in talking to younger voters, can take. And just to give you a sense of how prestigious this panel was. Obviously, it's the McCain Institute. They had Harvard's director of polling on there. They had a woman who's a fellow at the McCain Institute who was formerly the director of public policy for Snapchat, which is a big company. So I think that's certainly appropriate company for Avery to be in. And I felt like I thought was in many ways the most direct, not in many ways, in actuality, the most direct speaker there to how youth voting actually, how people younger voters actually act and what they're responsive to. And again, like I said, specific actions that organizations can take. So I was really impressed, and it's good for Avery. It was good for our organization, and and I think there'll be a YouTube about it at some point. So if you want to watch it, I recommend it. I also wanted to highlight that Gina has been teaching the Arizona Secretary of State's election officer certification training on voter outreach and education. Now, again, I just want to highlight this because, again, it's an important aspect of what we do, and it's an important linchpin in training election officers. In other words, basically every county employee who touches a ballot has to be trained through this process. So I think that having the recognition of Gina's expertise, and the commission's role in that process is important because, that certification process touches, so many people and helps validate the professionalism of our election officials in the state. I also wanted to highlight Alec is working and has created a guide for local jurisdictions on how they can include local candidates in the profiles on the Clean Elections website. And I think that's important because as we iterate our website to continue to be the best one-stop shop for voters in any part of the state, local candidates are a key part of that. We know from talking to local election officials over the years, local candidates is a thing they get questioned on, but because of their role, they're not in a position to provide that information. This is a way that we can help to serve both voters and local election officials. So, and when we talk about who our main constituencies are, obviously candidates are one of them because of the clean funding program and the debates and the candidate statement pamphlet, but election officials in counties and cities, and then obviously voters are the number one constituents. So I think that that's an important thing I wanted to highlight. You can see just obviously a continued effort on the part of everyone to get out and be meeting with folks, and really I think some of these efforts are really starting to gel in a way that I'm very happy about. One other note I want to mention, Gina and I yesterday went to a presentation in honor of the 33rd anniversary of the Americans with Disabilities Act which was presented by the Ed Pastor Center for Politics and Policy at ASU, the Arizona Center for Disability Law, and Ability 360. And that, itself was an important place for us to be. Something like 20% of all people across demographics have a disability, and not all those disabilities are visible. And accommodation of those people who have disabilities. I'm a lawyer. A lot of people on the commission are lawyers, and a lot of people who advise election officials are lawyers. And so, if you look at things through the ADA lens, you're looking at a sort of a minimal requirement, which is really not the same as what is actually necessary to actually try to meet a voter where they are and accommodate them. And we heard some stories about folks who've gone to what are nominally ADA compliant voter centers that don't in fact provide the access that is usable, right? So you have an accessible machine, but it's placed somewhere where there's not actually privacy taken into account. I think that that's important because we have through the ASL Canada Statement pamphlet, through Sun Sounds, and in other ways tried to broaden our approach to accessibility. And I think that's really something that is important, again, because it can just from looking in the room of folks who were there, we had just a broad diversity of people from different parties and different walks of life who sort of were able to talk about how the voting process, there's what is legally required, but then there was what is practically necessary. And that divide is something I think we can help inform our constituencies about. We continue to work with the Secretary's Office on the Election Procedures Manual and sit in on those meetings. We did the Arizona State Center for Inclusive and Sustainable Democracy launched a report last week that we helped support on independent election administration and on it was really a survey. It's a survey of more than 1,000 voters, and it really looked at what do voters like about the election system, what don't they like, and a couple of things that were key takeaways were voters do not like the partisanship within the election system itself. So that means, and then the two key things I think about that are important to bear in mind are voters are discouraged, at least say they're discouraged by a primary system that's maybe for partisan focused. And then with respect to election officials themselves, the United States is somewhat unique among Western democracies insofar as our election administration process is run by people who are elected in partisan elections, right? So, and this is something that some election officials who are elected have talked about as well, the need to have some kind of a nonpartisan aspect to that to try to maybe get try to build more confidence there. So we have some information there about the report. We will, I hope to, probably in the fall, we'll have Tom Riley, who's the principal author, here to talk to us through that. But I think there's a lot of insight there for a lot of the roles that we play, whether it's our policymaking role or otherwise. I think that the only other thing I wanted to note on the lawsuit front, I do want to just make sure two things. One, we had a result in the state case against Prop 211 that was good. The case was dismissed with leave to amend and file a new lawsuit. That new complaint was filed on Friday. If you'd like it, obviously we can send you a copy of it. And then the other thing we did do is we resolved the case called Legacy Foundation Action Fund earlier this month. That's been on this list for a long time, but that's now been resolved, and there's no further action for the commission on that. So I think that kind of concludes the report.
Thank you, Tom. Let me also just echo what you said about the McCain Institute Forum and Avery's participation in it. It was a very interesting forum, and I thought Avery presented some very, very relevant statistics on young voting, and also some excellent suggestions on how to get more young people involved in the process. And he talked quite a bit about the role of clean elections in educating voters. So I was very impressed, Avery. And I appreciate you doing that. Is there any other discussion or questions from members of the commission? Hearing none, we'll move on. Item 4, discussion and possible action regarding opening a public comment period on proposed rules related to the Voters' Right to Know Act, Proposition 211. As you can see, our agenda sets forth a number of rules that staff has drafted to begin the rulemaking process under the Voters' Right to Know Act. I'm not going to recite them all here. The public comment period is designed to solicit feedback from the public, the regulated community, and other stakeholders. The public comment period here will last no less than 60 days, and rules will be placed on the agenda for final approval after that time. We take public comment up through and during the commission's meeting to approve a rule. Actions we may take after a public comment period include deferring action, making changes to the proposed rules, and seeking further comment. Tom, do you want to give us a brief overview of the proposed rules?
Yes, thank you, Mr. Chairman, Commissioners. So at our last meeting, we began a public comment period on rules that were designed to address specific policy-related questions that the Prop 211 dedicates to us. For example, disclaimers on public communications, the process for notice of before someone's money can be used for campaign media spending. We did some definitional stuff, some basic work on timelines, those kinds of things. Those are currently out for public comment, although other than an initial comment we received with some clarifying questions, which we're working on responding to, we haven't received a lot yet. I assume we'll probably receive most of that towards the end of the 60-day period. Today, we are doing what I see as all likelihood the second and last big chunk of rules. And what I mean by that is not to say that we won't have other rules that we'll propose, but we really tried to break down this process into a section on 211 as it operates. It's 211 specific things, right? In other words, the substantive law of 211 requires us to take certain steps to fill in particular blanks identified by the statute. And we tried as much as we could to also lay out basic procedural rules like the time computations and such in that set. This set of rules has to do with the procedures around complaints, investigations, and enforcement. And so for the sources of these rules are principally, obviously, case law in the state. We looked to the Clean Elections Act rules themselves. We looked to the Secretary of State's Election Procedures Manual. We looked to the Federal Election Commission, and we looked to the not a broad survey, but we looked to a number of rules developed and implemented by other state boards and commissions as it relates to their enforcement authority. So the broad strokes are, the law allows and the rules create a process for if a person has a complaint underneath Title 16, Chapter 6.1, which is Prop 211, how to provide that to us. We retained from the Clean Elections rules the need to have that sworn and notarized. We think that at a minimum helps ensure some validity to the rules, helps ensure that we don't get frivolous complaints, not to the complaint process, we don't get frivolous complaints. And we think that works well. We also require that, as we do under the Clean Elections Act, for responses. There is we have a process for responding. Some of the highlights of what happens then are this set of rules more directly empowers the staff of the Clean Elections Commission to take investigatory steps in order to flesh out a complaint or ultimately dismiss a complaint, working with respondent. It then sets forth a process by which the staff and attorneys for the commission will work with the respondents and their counsel to, essentially, as we work up to a hearing, it has a specific pre-hearing conference. That's something that I don't think many state agencies actually have. But as we move towards a more of a formal hearing process here, rather than this more informal hearing process we've had under the Clean Elections Act, we thought it was important to build in that conference process. That conference will then result in a report that will go to the chair. Congratulations. Or the chair's designee to essentially do a pre-hearing order that tries to capture, how things will proceed. The goal here is to, end up with, rather than a reason to believe hearing and a probable cause hearing, is to have a single hearing where the issues, the factual issues are determined by the commission, and the assessment of penalties, if any, is determined by the commission. And then from there, obviously a respondent who doesn't like that outcome can seek review, or in the event that they don't, or whether they do or don't, the commission staff can seek to enforce whatever final order is issued by the commission. We think that, this is clear. We think it provides a sufficient protections to respondents in terms of their interests. And we think that, we think that this will be, a relatively efficient system for resolving complaints. One of the things we don't know, obviously, is what the volume will be, as we move forward, those kinds of things. We also don't know, as Commissioner Payton has mentioned in the past, we also still aren't as clear about what the person hours are going to be involved in this. One of the things that the rules make explicit, which has always been implicit in the practice of both the commission and the Attorney General's office, is that the commission will have to have an attorney who is your independent advisor to help assist not only with the hearing process, but with the pre-hearing orders. To make sure that, when you get this packet of information and recommendations that are hopefully jointly agreed to by both parties, to help sort through that. I mean, we put all that in with some specificity. Again, not to be repetitive here, but that's always been implicit, and some of it is explicit in the agency manual that's promulgated by the Arizona Attorney General's office. But in view of the litigiousness of folks in all parts of the legal process, we thought it might be better to just put it in there as clearly as possible. So, but at the end of the day, we hope that these rules come across as relatively intuitive to practitioners in this area. Obviously, most of the attorneys who appear in front of us are litigators, in their own right. So, I think that perhaps there's this might actually be more consistent or more comfortable for them than perhaps some of our more informal processes. I use informal not to say casual, right? I use informal to mean we haven't traditionally had live witnesses, just because people have never really talked about it. This would allow for that if necessary, those kinds of things. So So that's sort of the process here. As I say, we anticipate there will be. Oh, the other thing I should mention, sorry, I need to mention is we do have some rules on transactions and structuring, and those are designed to provide, again, a procedural backdrop for 16975 in particular, which says basically you oughtn't structure a transaction or attempt to structure or aid in structuring a transaction to evade the requirements of Chapter 6.1. So what are the things that we tried to do there were twofold. Number one, say, look, if you're a person who is in this process, who has information you're conveying, and the information you're conveying you reasonably believe to be accurate or true or believable, to you, you should be able to rely on that. But the trade-off for that we put in here, and people can comment on this either way, is, if it's not, that's not a carte blanche. We needs to be actually believable, or reasonably believed. We also talked a little bit about the evidentiary presumptions around structuring. So, in other words, and what it does is it said the executive director, when you're presenting a case, at least for civil purposes, that talks about structuring, we're going to have essentially a standard of having to show something of some willful conduct with respect to the transaction or the circumstance that you're operating from. And then finally, we have a provision that attempts to, for folks who advise people in the process of dealing with Chapter 6.1, to try to give them some latitude there, but we do want to make clear, and then we do make clear in that rule that, even if you're, if someone advising a client and enforcement or whatever is not going to be inherently, wouldn't be subject to structuring, some kind of being implicated in some kind of structuring scheme because of that, nevertheless, you cannot, and we have some reason to believe, based on public statements by folks, that in fact people are confused about the difference between advising people of the law and advising people to structure their transactions illegally. And so we made explicit, based on that, that, whatever you are doing for your client, you cannot advise a client to take actions or take actions yourself that result in structuring your transactions to avoid the requirements of the act. Why that's a point of confusion is a little bit beyond me. I don't know if election attorneys, if they've talked to their colleagues in the financial services bar or not. It doesn't seem to be that big of a problem there, but apparently it was a source of confusion we've learned through public statements by lawyers who work in elections. So that's why that's there. So we hope that together provides some clear processes for attorneys and regulated folks to work through problems there. It's also important to note that in the prior rule making process, we started a review process on an advisory opinion process, right? So you take these two things together. You have a rule that tries to outline what the procedures are going to be for transactions and structuring, but also that's where this advisory opinion piece becomes important, because there's no reason to be on sort of a lark, or there's no reason under this set of rules to be acting with uncertainty about whether or not you are engaging in something that would be considered structuring, because you have a clear, assuming all these rules are finalized, you have a clear opportunity to have the commission independently provide an opinion you can rely on about whether or not what you propose to do is appropriate, and you have guidelines about what we think, generally speaking, will fall in or outside those lines. So I think if you take those two things together, it's very difficult to see how, for me anyways, to see how someone would have a serious problem with respect to that.
I have a question.
Sure, please.
Commissioner Payton?
A couple things. So if we are having, does that involve extra personnel to do that? Are we have a different budget? Is that coming out of the budget that we have now? And as far as somebody that advises us
Right.
on this, is that a separate lawyer than what we have now, or is it from the Attorney General's office, or how does all that work, I guess?
Sure. No, it's a very good question, Mr. Chairman, Commissioner Payton. So from a budgeting perspective, we are hopeful that our budget process over the next few months will be a little bit more involved than it has been on a variety of different fronts. We will have to engage with the Attorney General's office on this. The statute permits us to hire counsel outside of, well, it's unclear to me if it allows us to hire entirely outside of the procurement process outlined in 41-192 and 41-2518, but it nevertheless allows us to select counsel. So how that will work is probably something we will coordinate with the Attorney General's office. How much more additional funding that requires is a little unclear to me at this point. I am hesitant to staff up with full-time staff until we have a sense of what the real amount of complaints really is, because there's a lot of there's just a lot of what are they called? ERE. There's a lot of ERE costs associated with that, especially if you're hiring someone who is essentially has a JD. So that's probably something. That's something I think we will over time be able.
You mean
to talk.
that's a lawyer?
Right. Yeah.
Okay.
Yeah. But lawyers are expensive, and lawyers by the hour are actually cheaper than lawyers. For us, lawyers by the hour are less expensive than a permanent lawyer on staff who. And then there are questions, and I don't know how. I'm just throwing this out here, which I shouldn't, and I'm sure Kara and Mary are going to be not thrilled that I say this, but there are substantial questions about how arm's length the relationship with the lawyer has to be. In other words, can the commission actually hire a lawyer who is their independent advisor without that lawyer then becoming subject of being pilloried in a later court opinion? We don't know the answers to those questions. We'll work through all that. My hope is that, and how this should ultimately end up working is that the most important points are going to be that the attorney who advises the commission's loyalty flows to the commission, to you all, and not to the staff, and that there would be a conflict for that lawyer to come across the sort of wall we try to erect in these rules. What I think will take the most work is ensuring, and this is something that I will work on, and I, to the extent that, and I, obviously will engage with Kara about this, is making sure that the Attorney General's office understands that person will have to have substantive understanding of this statute, and that will benefit not just the commission, but the respondents, right? In other words, what traditionally the Attorney General's office has done for independent advice is they have attorneys who work in, say, the licensing bureau or some other place who can come in and and you've had this, right? And some of those lawyers are very good and very much understand the situation. And a lot of the procedural aspects of hearings are the same. Doesn't matter, right? You're talking to the fingerprint board, you're talking to the elections commission. A lot of the basic due process law and stuff that they're guiding you on is the same. However, this rule requires them to be able to understand why, why a scheduling order would require the things it would be required, and sort of requires a little bit more subject matter expertise around these areas. For example, if you were to, let's just imagine we get to an end of a case and you want to issue a final order. A final order, you might not like, the rules contemplate that the respondent and the staff can both provide you draft final orders. You might not like either of those. The attorney who you would ask to write one that you like will be this independent legal advisor. That means that person has to understand the law at play in order to draft that order properly, right? So it's a substantial question, and one that we'll kind of have to work through. But right now, and it may very well be that what we do is we end up having to hire somebody who's outside to do that. I mean, I don't know, depending upon if there are attorneys who have, who have not been on one side or the other, or who are not currently, sort of engaged in, representing clients, particularly partisan or ideological clients, before the commission or before other campaign finance cases. So it's a really good question, and the reason I give you such a long answer is because these are all questions we'll have sub questions we'll have to answer. And so what I'm trying to just demonstrate is our awareness of that, and how we can hopefully work through that over the course of the next 6 months or so. I'm
just concerned that we've got all these proposed rules, and the public comment that we've gotten is pages that seems to me this could become fairly cumbersome and may overwhelm us, I guess, because it's an unknown,
right?
And obviously the person that advises us or advises the people interested that are coming for answers to questions that they have, it could be a whole little staff, right?
Yeah, right. Yes, that's correct. So, I mean, certainly other agencies that have similar responsibilities to ours in other states, and certainly at the federal level, have bigger enforcement staffs than Mike and me. But as I say, I mean, I am still not convinced that the problem is that, I mean, the real problem becomes, just as a budget matter and as a practical matter, if there was, like, let me give you an example, and this is a free idea for the Attorney General's office. If the Attorney General's office was to create a bureau of independent advisors whose job was not to be in the attorney contact point for the boards and commissions and other agencies that do enforcement, but rather was designed to have broad subject matter expertise in all of the different enforcement regimes in the state, and could provide those attorneys to agencies on an ad hoc basis, that would be a way that we could the boards who are all in a similar situation could address this kind of issue. And what that would mean would be, you would take, let's say you hired 5 attorneys for that, and you broke up the major areas of state regulation. You had a health and safety person, you had a person a health person, you had an election person, you had a person who deals with the Board of Technical Registration and the Registrar of Contractors. If that person could be cross-trained on some of those things, it would be similar to how the way the Legislative Council has the set of lawyers that work for the legislature, and each one of those legislative lawyers has a
Like a utility player.
yeah, exactly. Each one of those attorneys has a part of the Arizona revised statutes that is their area. And so if something comes in, someone wants a bill written about Title 16, they go to one attorney. If they want a bill written about the tax code, they go to another attorney. That would be a way in which the Attorney General's office could better deal with both the increasingly I shouldn't say increasing, the changes in administrative law that are coming out of our court system, the changes in administrative law that are likely to come out of the federal court system that may apply to state institutions, and also maintain, especially in those areas where health and safety are critically important, maintain a context where all of the respondents get all the due process to which they're entitled to, but the public and victims in the cases of health and safety issues are also protected by the boards being able to act independently. That's my dream solution to this problem. But because I just don't think that each individual board trying to create a huge staff for this is probably very effective, and it's much more expensive.
So my understanding is this bill, this became law.
Yeah.
And we're responsible for it.
Yeah.
But we weren't funded for it is what I'm asking.
Right. So that's a good question. So Mr. Chairman, so there's a 1%. There was a 1 percentage point increase in the surcharge that funds the Maine Clean Elections Act. It is the payments for this. There are caps under the Clean Elections Act for expenses under that article that don't appear to apply to this chapter. But I would say that, let me put it this way. I think it's like something, what was the number? You give me the number of where we were at roughly. Right. So far the 1 percentage point increase has provided about 72,000 in new revenue. That's for obviously for startup purposes, that's not even in the ballpark. What could, if that's over 6 months time, let's say, and those revenues have not been consistent over time, but let's say that raises $100,000 to $150,000 a year in additional revenue for this particular project. That's not going to cover the cost of it. Now, the Act directs essentially the Clean Elections Fund to provide funding for that, so we have funding available to backfill that. But so this is, and then that doesn't affect the general fund, which is the most important legal aspect of it. But no, this doesn't pay for itself. But more importantly, the other problem here is that there are legal changes to the way administrative law is done that are coming, whether they're coming in the form of the Legacy Foundation case that we just resolved, or coming in the form of cases that are now pending at the U.S. Supreme Court that are going to require all of us, not just us, but everybody who does this kind of work to evaluate what the costs are going to be. They're going to raise the costs of enforcing laws, whether it's a law related to a doctor who gets in trouble with Bomex, or an acupuncturist, or an independent expenditure, the person who makes independent expenditures. They're going to raise the costs of enforcing the law against those folks. There is, and so I guess what I'm trying to say is your questions are exactly right. It's just that there are a bunch of different factors that are going to play out that are going to determine how that gets paid for, that all the chips haven't fallen yet to know how that's going to work out. My hesitancy as executive director to bring on new staff members is I don't want to bring in somebody who's going to end up not having a lot of work to do. A lot of this will end up inevitably falling after, we managed to run, for the most part, the Clean Candidate program with the most of the candidates, not all, but most of the candidates and the independent expenditure reporting program aspects of the Clean Elections Act, with basically Mike and I with assistance from Kara, but pretty efficiently on a financial side. There are some cases that blow up, but they don't blow up every time. This one is a little bit different. And if the Clean Elections Act started up in 1999 through 2006 is any indication, there were way more, and I think Mike, tell me if I'm saying the wrong thing, but there were way more things that turned immediately into sort of real litigation outside of just the administrative process. And at that point, that really is going to necessarily involve attorneys, but not necessarily but it doesn't make any sense necessarily to have, it's not the kind of attorney that you would necessarily employ in-house. It's inevitably going to result in, whether it's the Attorney General's office, depending upon the circumstance, or an outside counsel, whether that's Mary or that's what Mary's role has been in a number of cases. I don't have a quantitative answer. I only have qualitative answers on this question.
So it's the great unknown.
Yeah, yes, it is. I mean, we have the money, provided the budget doesn't go, the overall state budget doesn't go away, and we don't find ourselves, cannibalized. But
I just feel like, what if it turns into a significant thing? And I doubt that the legislature is gonna, try to help us out. And I guess if more people get fined or whatever, that would be made but I thought our revenues were kind of going down for a couple of years.
For sure. All right.
So that's,
Yeah.
and maybe I'm making a mountain out of molehill, but I think try to plan what could happen.
Mr. Chairman, Commissioner Payton, no, you're not making a mountain out of a molehill. You're identifying real concerns that we really talk about internally a lot. It's just that it's hard to get. It's just hard to get ahead of. I mean, we know there are administrative law decisions that are on the docket at the U.S. Supreme Court right now that may have a trickle-down impact on the way everybody who enforces law through an administrative process does business, right? And why does that be? And that will alter the terrain potentially significantly, and it may really affect the costs quite a bit. But until those happen, the most important thing for us is to be able to tell you what we're considering, what we think is our solutions to those things if they were to occur. And then the big unknown, the biggest single unknown is what is the volume of complaints going to be, and what is the volume of complaints that will actually have to be resolved by a hearing. I would say this is a rule of thumb, but I would say 9 times out of 10, we are in the context of independent expenditure reports and in the context of clean candidates, we are able to resolve complaints without any kind of hearing by virtue of by just staying on top of them, addressing them quickly and resolving them in the most efficient way possible. We have not, for example, culturally had an approach that says that enforcement for the purposes of extracting financial penalties is our focus. The other X factor, just to throw it out there, just so you have more awareness, is this act is much more explicit about the rights of folks who are dissatisfied with our decisions to sue the commission. That's a whole other cost that the Clean Elections Act does not does not make nearly as explicit. And in fact, we've had many fewer lawsuits along those lines than this would. That happens at the FEC all the time. The FEC, that part of the law is very similar to what the FEC faces. I guess what I want to say is I am just small c conservative about wanting to invest the money in employment costs up front before we have a better gauge of because we can ramp up stuff. It's a lot easier to ramp up than it is to ramp down.
I guess maybe what I'm thinking is that maybe we can try to figure out like a job description or whatever and have that kind of stuff set up
Yeah.
if we actually need it.
Yeah.
And have it ready to go. So, before it envelops us, if
Yeah.
something happens.
I think that's Mr. Chairman, I think that's a good idea. We have had some conversations. Along those lines, I had a very good suggestion from somebody just the other day in a meeting about whether or not we needed to set up a more formal enforcement division, on paper. So, so I think that's probably not a bad idea. We could sort of have,
we already have 5, 6, 7 legal issues.
Right.
Like we look at like every time we come.
Right.
And this could just, and like I said, we are seeing these comments
Yeah.
that are pages long.
Yeah.
So people are already thinking about stuff. And
Right.
so if that's the case, then I think we should be prepared for it though.
Sure. I take that point.
Okay, are there any other questions or discussions from members of the commission on opening a public comment period? I will note we received a written comment yesterday from Lee Miller Law. Is there anyone else here who wishes to make a comment on the draft rules? Seeing no one, do I have a motion to distribute the rules identified in item 4 of the agenda for public comment? No one wishing to make a motion?
I'm sorry, I can make that motion. Mr. Chair, I move that we circulate the rules on item 5 of the agenda for public comment as proposed by staff.
Commissioner Meyer, that's actually item 4.
My apologies, item 4.
Okay, thank you. There's been a motion to distribute the rules identified in item 4 of the agenda for public comment. Is there a second?
Second.
Seconded by Commissioner Payton. I will call the roll. Commissioner Payton,
Aye.
Commissioner Titla,
Commissioner Titler, you're on mute.
Commissioner Titla.
Yeah, hello?
Yes. How do you vote on the motion?
Oh, aye. I vote aye.
Okay, thank you, Commissioner Titla. Commissioner Meyer?
Aye.
Chair votes aye. The motion is approved 4-0. Item 5, discussion possible action on the following 2022 primary and general election candidate audits. Mike Becker's going to make some general comments on this item. Mike?
Mr. Chairman, Commissioners, thank you. Before you are the final 2 audits for the 2022 election cycle. One is a primary, one is a general. The audits turned out fine. There's nothing exciting or major to discuss in them. I would like to say thank you to Fester and Chapman, the auditing firm that we've worked with for several years. They do an amazing job. They have a lot of patience with our candidates, and they do a phenomenal job getting the information that we need. So can't say enough about them. But with that being said, those are the last 2 audits, and I ask that you approve them, and we can close the book on 2022.
Thank you, Mike. Is there any questions or comments from the commission on item 5? I'll entertain a motion to approve the audits identified in item 5 of the agenda?
Make a motion to approve these audits from item number 5.
Thank you, Commissioner Payton. Is there a second?
I'll
I second it.
Seconded by Commissioner Titla. I will call the roll. Commissioner Payton,
Aye.
Commissioner Titla,
Aye.
Commissioner Meyer.
Aye.
Chair votes aye. The audits are approved 4-0.
Thank you.
Thank you, Mike. This is the time for consideration of comments and suggestions from the public. Action taken as a result of public comment will be limited to directing staff to study the matter or rescheduling the matter for further consideration and decision at a later date or responding to criticism. Please limit your comment to no more than 2 minutes. Does any member of the public wish to comment at this time?
Yes.
Okay. I couldn't tell who that is who said yes. Eli?
Yes.
Okay, could you identify yourself for the record before you make your comment, please?
My name is Eli Dalton Webb. I am a registered voter and resident of Cochise County, Arizona.
Okay, Mr. Webb, go ahead with your comment.
All right. One is I'm kind of concerned and a little bit disappointed about how much is the Clean Elections Commission spending on attorneys? Because I really felt like listening to that guy. He spoke for an hour and it was a lot of almost nothing. It was a lot of legalese that I don't think is leading anywhere. So I'd kind of like to know how much this guy is getting paid, and I really think that it's the government milking the clock on that one. And the other thing that I'm concerned about, which is a even more serious concern, is the throwing everybody in the primaries, throwing everybody in the primary debates. I'll give you a very specific example. So the Republicans and Democrats are going to try to go after the Corporation Commission, as usual, right? Which that's to be expected. I believe there's 3 seats that are open. So if there's going to be at least 4 Democrats and at least 4 Republicans, they're all going to get thrown in the same primary debate. But if there's one libertarian that runs for the Corporation Commission, they're not going to be invited to that primary debate where they're going to get, but the Republicans are going to be debating against the Democrats, but the libertarians won't be invited because they only have one candidate. So, it really alienates anybody or any party that has equal to or less than the amount of seats that are up for election. So that's pretty concerning. The primaries are supposed to be for the primary election. It should be party against party. And then for the general, then throw everybody in. And that concludes my comments.
Okay, Mr. Webb, just to clarify on your first matter, you talked about some gentleman who spoke for about an hour. Are you talking about Mr. Collins here?
Yes,
Okay.
I don't know.
Okay. I'm pointing to Mr. Collins, who's sitting to my left. Is that who you were talking about?
Yes.
Okay. I just want to clarify your comment. And I don't know how much I want to get into this about the debates, but the debate is set up so that people who have a contested primary debate each other. And if there would be 2 libertarians running, they would debate each other. if there's only one and they don't have a contested primary, they probably wouldn't be participating in the debate. But we appreciate your comments and thank you for attending the meeting. Is there any other member of the public who wishes to make a comment? Seeing none, we will move on. The public may also send comments to the commission by mail or email at ccec@azcleanelections.gov. I would now entertain a motion to adjourn item 7 in the agenda.
I would make a motion to adjourn.
Commissioner Payton has made a motion to adjourn. Is there a second?
I second.
Commissioner Titla seconds. I will call the roll. Commissioner Payton,
Aye.
Commissioner Titla,
Aye.
Commissioner Meyer,
Aye.
and the chair votes aye. We are adjourned until August. Thank you.